with the Pacific Legal Foundation, and we'll discuss the general plan of copyright issues.
So I did that.
I don't know.
CCTA alternative proposal. It was also involved in helping the struggling farmers on the valley shut-off issue. And the interesting thing was happening there because it does affect our state record. Pacific Legal Foundation was established March 5th, 1973. It is the oldest, most successful public interest legal organization that fights for limited government, property rights, individual rights, and a balanced approach to environmental protection. He brought some literature which is on our table, and unlike me, he's going to give it to you. Luke. Thank you very much.
Well, and thank you all for inviting me out here. I appreciate having the opportunity, really the excuse to be here in a beautiful town. And as you mentioned, I'm an attorney at Pacific Legal Foundation in Sacramento, and we are dedicated to the fight for liberty and for property rights in this country. And it is an uphill battle. As you know, there's a lot of overregulation going on today, and as you're dealing with this general plan update business, I'm sure that this is an issue that's hitting home to you because this is going to be affecting how you will be able to use your own property in the near future. I primarily work in our property rights group, although I am involved also in some environmental cases, also enforcement of Proposition 209, which if you don't know what Proposition 209 is, California voters in the 90s adopted Proposition 209, which requires the California government to make all decisions without consideration of race or sex, which makes perfect sense. You shouldn't be worried of anything or discriminate against on the basis of such things. And unfortunately, a lot of state governments, like San Francisco, continue to violate that with affirmative action programs and whatnot. So we stepped in, and we have cases in the California Supreme Court that just argued a few weeks ago about that. So we do a lot of good stuff, but it's somewhat, as I gave the analogy to someone I was talking earlier. It's like trying to empty the sea with a cup. There's a lot more than we can handle. But we've been to the Supreme Court 6 times. That's the U.S. Supreme Court. We've won 5 of those cases. So, and the most recent case that we won in the Supreme Court was a case called Panos in the United States. That dealt with, it dealt with how much jurisdiction the Army Corps of Engineers actually has over land with the Water Act. Because they were trying to basically say that the Clean Water Act would allow them to regulate anything and everything that had within any vicinity of water. And we said, no, well, the Commerce Clause of the United States Constitution doesn't allow you to do all that. If you are not familiar with the Commerce Clause arguments that are floating out there with regard to healthcare legislation, I'll give you a real quick background on that, because that's actually something we're very involved with. Our Commerce Clause litigation is actually going to be getting us involved with the healthcare challenge that you probably heard about the state attorney general's bringing and whatnot. The federal government obviously has only those enumerated powers which the Constitution explicitly gives to it, and those enumerated powers have been expanded so greatly by progressive interpretations that they've effectively lost most any meaning. So we get away with most of how they regulate us today through the Commerce Clause, which authorizes them to regulate interstate commerce. And traditionally that meant that they could regulate goods or services that are actually crossing state lines, but now they want to interpret that so liberally that they can regulate anything that has any sort of tangential effect on the economy. So, we actually had a Commerce Clause win in that Rapano's case, and here we're going to be challenging the individual mandate provision of the health care bill, which requires individuals to purchase health care. This is actually, I think, a pretty big issue as far as liberty concerns go. If the government can force us to be market participants, then the Commerce Clause effectively lost all meaning. Anyways, we also are very active in the property rights arena, which is of course why I'm here today, our biggest nemesis is actually the California Coastal Commission. We do a lot of work against them. They produce a lot of interesting cases for us because they take regulation of property to new extremes. And actually, one of the cases that we went to the Supreme Court with in the 80s was a case called the California Coastal Commission. The California Coastal Commission was trying to basically force a property owner to give up an interest in their land, basically making them give up the right to exclude people from their land in exchange for a building permit. And the Supreme Court said, you can't do that, that's like extortion, which is exactly the argument we were putting forward. Now, actually, just recently we won another case against the California Coastal Commission under similar circumstances. You had a family that's just seeking to get a permit for a house, and I mean, it was just a modest family home for 4 children and a mother and a father. Well, in exchange for that, they wanted them to dedicate as open space about 80 acres of their property. Not only that, they wanted them to guarantee that they would farm the property, and this property has no history of farming, but they wanted them to give an easement which would require them to farm their property in perpetuity, which means forever. So very absurd, and again, that's just another example of government trying to take away people's rights and usurping the constitutional guarantees. Now, Al gave you a lot of great suggestions for reading material, and I particularly recommend the law that he mentioned. These things talk about, the law talks about our natural rights, and the Founding Fathers really did believe in this concept of natural rights. The idea that there are moral constraints on legitimate governance, that is to say that government can't just do whatever it wants to us. That is to say that there are limits on what they can do. And they sought to protect us by creating a constitution that would, one, only give certain powers to the government, and two, would, when they passed the Bill of Rights afterwards, they sought to solidify a certain set of rights that said under no circumstance can the government ever take away those rights. But the Bill of Rights, mind you, is not the only, it's not the complete list of our rights. Actually, the Ninth Amendment, which has pretty much been mooted at this point, provides that all rights not specifically listed are nonetheless retained by the people. And that, as I will explain, is no longer really the case. Our rights under the Ninth Amendment, and for that matter, our property rights, are more or less treated as privileges today, which is scary, and which is why my advice to you with regard to this general plan amendment business is that you better win on the political arena, because you don't want to have to fight battles for your property rights in the courts, because it is an uphill battle. Now, James Madison, in Federalist Number 10, spoke of what he called the problem of factions. He said that the biggest problem he could see with in government is the potential for certain factions to try and take from others their liberty and their property. And so when he drafted the Constitution, he explained that his whole purpose was to sort of find a solution to this problem of the faction, to keep factions from hurting the rights of other people. And I think he was wise on it. And what we have here in the general plan process that you guys are going through is that problem exactly, the problem of factions. Now, here, you guys, I think, are in the right camp. You're fighting to defend not only your rights, but the rights of every property owner in a county. And I think that's fundamentally a good thing. But the Founding Fathers were right when they said that the democratic process, which I know everyone says, well, we have a Republican government, but fundamentally, I mean, at the end of the day, it's more or less a democratic system because people vote, and we have a problem of the majoritarian taking control. I I always like to put it in these terms. Democracy sometimes can be like two wolves in a sheep arguing over what to have for dinner. and I think that's the case here. If the majority alone decides how decisions will be made, the rights of the minority will be trampled upon. And then alternatively, there's a school of thought called the public choice theory, and it's the notion that special interest groups, certain factions, can take from you your rights by basically lobbying and putting a great deal of effort into achieving a policy that is favorable to them or to their vision of how things should be. So this is very much a political issue, and but of course there are legal aspects to it. And I wanted to, in the time I have here, touch upon, explain to you what the general plan process is, so you know where we are, where we're going forward, and explain to you a little bit, give a little more context to what I was saying about the state of property rights in America today. Now, in California, every community, every municipality and county is required to have a general plan. A general plan is basically the constitution for development in a community. And these concepts of general plans actually started coming into vogue, if you will, in the 1920s, which was the progressive era, the time in which people began to shift from thinking about natural rights in the way that the founding fathers did to this more sort of collectivist New Deal notion that there's no rights, we can do whatever people think ought to be done in a very rational, scientific way. That's all well and good, and it makes sense to some degree to plan out, infrastructure and things like that. But you run a risk when you get into this planning business of controlling people's lives. Now, the founding fathers really did believe that the right to property was the most important of our rights. This is because without property rights, you have no livelihood. And as you'll see with land use planning, what you are and are not allowed to do with your property affects you a heck of a lot more than most regulations that are coming out of Washington, because this affects your community, affects your daily life, affects what you can do in your own home. So getting back on course, the general plan process requires every county to go through what your county is doing right now. They have to come out with basically a long-term plan for development, and this is going to sort of decide the course of your future and the future of your community. Now, in doing this, they consider how densely do we want to develop an area. They consider where development should occur, how much should occur, how it should be done, and they don't get into necessarily all the specifics that you might in zoning law. Now, of course, once they've established this general plan, everything that happens in your community will have to be done consistently with the general plan. That is, when the commissioners create zoning laws, the zoning laws will have to be consistent with the general plan. In order to do something inconsistent, you have to go and get an amendment to the general plan, which is a political process and is very time-consuming and costly, especially if you're the one lobbying for a change. So you really don't want to be in that position. Also, when you go to develop anything, to build anything, you have to go and get building permits, and that has to be they have to be issued in accordance with the zoning laws and the general plan. So you have to. This is going to be very important for you, and I think it's important to understand how that process goes forward. Now, I understand that you were concerned with what CEQA would implicate in this process. CEQA is the California Environmental Quality Act. It was promulgated in 1970 by the California legislature, and it is widely used throughout the nation, really. as sort of a model for environmental policy. Because what it does is it requires the government in every decision-making process to consider the implications that their decision may have on the environment. So this means that in the land use context, those decisions have to go through what they call CEQA review. Under CEQA review, the first question they will consider in any sort of decision, and now this applies not just to the adoption of general plan, it applies to any government decision, for example, the adoption of new zoning laws. Guess what, when you go and apply for a building permit to have the extension of your house, or a new garage or whatnot, you have to get a permit, they have to approve it. That's a government decision right there, and so CEQA applies again. So they consider, basically, they have to make a determination once they decide that it's going to have an effect on the environment. They have to decide, was it a significant effect on the environment? And once they come to that conclusion, they say, no, there's not going to be a significant effect on the environment, and they file what we call negative declaration, and you can go on with your project. Now, if they decide that there will be a significant effect on the environment, then you have to go through a very costly and time-consuming process, preparing an environmental report, basically, which considers and proposes all of the possible alternatives. One of those alternatives being nothing at all. And then they have to go with the alternative that is the least harmful to the environment. It's not the best thing for the environment necessarily. That's not the proper way of thinking about it. The proper way of thinking about it is what is the least harmful alternative. So that's something that is going to come up whenever you seek a building permit, and it's something that's coming up right now with regard to your general plan. So what does that mean? It means that your general plan has to comply with the CEQA business. And so as much as we all want and believe that property rights have to be considered, CEQA will have to apply whenever the government makes any sort of decision on property. That being said, I can't give legal advice today, but I can give a suggestion that you might benefit from having an environmental lawyer draft some language for you regarding that. But the basic point is, you can say, and I think with a very straight face, that that in our community we want our general plan to reflect values that respect property rights, and that we're nonetheless going to go about things in an environmentally responsible manner, and that, well, because that's what CEQA requires whenever there's a decision made on a building permit anyways. Ultimately, whatever your general plan comes out looking like at the end of the day, whatever development happens in this community, as with anywhere else in California, is going to have to go through this CEQA process. So I think that just as a matter of tact, as you approach these things, you should be careful to say that, well, we really do want to see property rights respected, but we also recognize that things need to be done in an environmentally responsible way. That's what the law is here in California. Now, if you want to change that, you're going to get rid of people in Sacramento. But next year. Now, I understand also that there's a lot of concern here about this whole concept of smart growth. I was talking earlier about factions. Well, you guys are fighting for property rights, but there's other factions out there that see things a little differently. There's more by what I would call the collectivist mind state, that they're not so concerned with individual rights, they're concerned with what their vision of utopia is in this community. So sort of reminds me of a book, I don't know if anyone who's ever read Hugh Levin's 1970 book, This Perfect Day. But in that book, it's a good read actually, but he talks about this faceless bureaucratic decision maker, a central planner, if you will. And this central planner is making all of the decisions throughout society as to how land should be used, how cities should be run. He makes every decision, how long we should live, as well as what we should do on a daily basis. Well, that's what we call social engineering. He was basically taking away all of the rights and the liberties and I would say the dignity of each individual by making all of these decisions for them. And he thought that he knew best, or Uni thought he knew best how communities should be run, how people should live their lives. Well, that's exactly what these people who advocate smart growth think. They think that they know best how the community should be run. They think they know better. They knew how your property should be used. And they somehow think that they're smarter in the way they go about it. Well, I think that individuals know best how to pursue their own good, and that as long as we respect our neighbors and their rights, all will be well. So I think we very much should be skeptical of this notion of smart growth and this notion that some central planner can know best for the entire community how things should be run. Because no matter how noble and whatnot that their objectives may be, that their motives may be, at the end of the day, no individual, no table of bureaucrats can know what is best for each and every individual. So I think you are doing the right thing and fighting for all of this. I realize that I'm at about my time here, so I am happy to answer some questions and specifically with regard to the state of property rights in America today. But I will entertain questions at this point.
Yeah.
I'm interested in what your opinion is on private property water rights and how that would even relate to Nolan.
Private property water rights? Well, that's a good question. And obviously water is a hot topic here in California as throughout the West. And I think increasingly so in the coming years. And as I don't know if I mentioned this in the beginning, but we're very involved with the Delta Smelt litigation down there in the Central Valley, trying to get water turned back onto the farmers. I will say that under the law, individuals do have certain rights to water and to access water, and where there is an entitlement to access a certain amount of water, that has to be respected. Now, the folks down in Central Valley have the water turned off, and that is obviously causing all sorts of problems for them. I imagine that, are you guys facing similar issues here?
Well, I'm talking about individual water rights for each, when you buy a piece of property, you get your water rights, and now there's talk about putting meters on wells. And that gives government intrusion into your private property rights. So I wonder if there's been any discussion of that, or, and it seems to me like on the Nolan case, it would follow parallel to the Nolan because that would be a taking.
Well, I think to answer that question, I have to explain a little bit about the state of takings jurisprudence in this country, which kind of brings me round about to my point about how property rights are treated more as privileges in this day and age. In order to win a takings claim, I mentioned in the beginning that the Fifth Amendment protects the right to private property unless just compensation is paid. But under our current jurisprudence, in order to demonstrate that your property has been taken without just compensation through regulations, for example, a regulation requiring you to do X, or restricting your use of the property, or restricting, in this instance, your right to use water, you have to prove that your property has basically been denied all economic beneficial use, which usually means that you have to prove that your property has been deprived of any sort of use. If, for example, you're denied complete access to your property, or possibly if you've been denied all water, you can say that because you're obviously under state laws, you're not allowed to develop, you can't have access to water. So there's a possibility for a taking there. But that's usually regulations don't go that far. Usually, in this instance, they probably limit how much water you can have, which probably wouldn't go that far. And in instances where a regulation doesn't actually completely deny you of all economic beneficial use for the property, then you get into this sort of conflated sort of balancing test that's wishy-washy that the Supreme Court considers or calls the Penn Central test. And under Penn Central, they consider how much value of property is lost as a result of the regulation. They consider whether or not you had investment-backed expectations. That means when you bought the property, you had to have plans to do something with it, and you had to have evidence of that. And then thirdly, they consider the character of the government action, whether or not the government looked like it was out to steal your property when they did it. So in this instance, I mean, if they're merely restricting how much water you have access to, it's, you probably would be stuck in that Penn Central test, or someone would probably be stuck in that Penn Central test, and it really is sort of a crapshoot at that point as to whether or not you win. And that's why, with regard to the general plan, I say you absolutely don't want to end up having to litigate the case. Okay.
Yes, my question has to do with agriculture. It always seems to be county in any general plan that I can work on. My question is there any kind of government agency that mandates that a community has to have agricultural land, and that it should be outside the general plan because you have rural entities being turned into development for single family dwellings and that sort of thing, and then you have land that used to be farming no longer can be farming because of the community that's surrounding it. And to give you an example, Napa Valley and the cattle industry that happened there. Is there anything from a government level that helps ensure that we have agriculture in a general plan?
Well, the general plan process is ultimately decided by your local officials, called county commissioners, and they are free, as I explained, sort of the constitution for how the land development is going to occur in the county. So they're free to do what they like within the bounds of the U.S. Constitution and the California Constitution and applicable state regulations. Now, there are some state regulations that require the general plan to preserve some degree of open space, and typically communities will have open space requirements and try to encourage farming and agricultural uses actually under the open space requirements that we recall. But the community is more or less free to decide in its general plan what sort of values and what sort of uses they want to see. And the general plan is done, and all land use regulations are done under what we call the police powers of the state. Which is basically the power to regulate in the interest of health, safety, morals of the community, and the general public interest. And under our jurisprudence, they basically are allowed to do anything under the police power that is considered to reasonably advance a legitimate state interest. So what that means is that most of the decisions as to things like this are going to be decided under what we call the rational basis test, which is a terrible test. It's complete deference to government. It basically means that, look, if you can come up with any conceivable basis for how we can say this is reasonable, I mean, and you don't even have to say that the legislators had that reasoning in their mind. The judge can think it up for them. They could be blindfolded, not thinking when they pass whatever they pass. But as long as the judge can think of some rationale behind it, it will be upheld. And that's why I say state of our constitutional rights is imperiled.
Probably yeah, just be the simple answer. What's easier? Change the law or change the lawmakers?
Well, to change, I probably change the lawmakers because
I'm talking about efficiency and cost.
By efficiency, well, you can't change the law without changing the lawmakers.
Okay, so the easiest direct way to change is schmucks to make those bad laws, right?
Well, yeah, but the question is whether you can put the people in, whether they're going to be any better, so.
Well, we get what we.
Thank you, I appreciate that.
How about one more question?
This is going to be an answer.
This will be the last one. We haven't heard from who else. One more question.
Okay, go ahead.
I was just wondering, you don't give us much vote. Now, are you saying it's up to the planning commissioner or it's up to the community? Because in that last answer, you said both. Who's it going to be up to,
Well,
the general
ultimately,
plan?
the general plan is going to be decided by the legislative body, that is your commissioners, or for board of supervisors. So they'll make the decision, and I mean, ultimately, they're accountable to you guys in the elections. their decisions, but they make it, and as long as there's a rational basis supporting what they do, it's usually going to be upheld, unless it goes so far as to be taken, as I explained to you. So,
Thank you.
Unless they get voted out. Thank you, Lou. He's not getting off the hook. We'll continue on the same theme with Tanya and Mike. Tanya and Mike Dawson have been working really hard for the property owners and taxpayers. And Mike has written most of that alternative D that you heard about in the paper. And so they'll be up there, they'll be talking about that. Their chart is back there. We might maybe bring the chart up if they need it. And then as we get into discussions about some legal aspects, of course we got Luke right here to help, so he's not getting away. All right, Tanya, Mike, you got the podium.
Thank you, and thank you for the opportunity to speak here today. I wanted to start out with a quote by George Sutherland. Can you hear me okay? So, okay. He is Associate Justice of the United States Supreme Court, and he wrote, "The three great rights are so bound together as to be essentially one right. To give a man his life, but deny him his liberty, is to take from him all that makes his life worth living. To give him his liberty, but to take from him his property, which is the fruit and badge of his liberty, is to still leave him a slave." So, under this new general plan, the terms and conditions under which you purchased your property may be changing without your permission or just compensation. On April 20th of 2010, our Board of Supervisors chose a hybrid of alternatives B and C for the Calaveras General Plan. These alternatives change land use designations without property owner's permission. Some people may be losing their right to build an accessory building, in-law quarters, under this current proposal. Other people in the county wishing to enjoy the country life, who intentionally purchase property in low-density areas, may find themselves suddenly living in areas designated for much higher density. Others who invested the fruit of their labor in property on which they have the right to develop and perhaps later sell to fund their retirement may lose those rights. Business owners who bought commercial property may find that their property can no longer be sold as commercial as they had counted on. In the project development maps, I have a map at the back of the room here, and there are two maps. Thank you, Al. The maps have orange dots, and the orange dots, the little tiny orange dots, they represent potential dwelling units or homes. Mike, do you want to hold that for me? So, notice on this map, the dots are spread throughout the area here. And in this map, the dots are missing. For every missing orange dot here, that's a property right that's been taken away, where somebody had the potential to put on a home, and under this plan, have lost it. Because people should have all the rights and responsibilities that came with their property when they purchased it, concerned citizens of Calaveras County have joined together to write an alternative for the general plan that protects property rights, and that's alternative D. So, and this is a lot of us got together and put our heads together and came up with this, and Mike put all the information together into this document. So, yeah, oh yes, and it's on the Calaveras Taxpayer Association website. Alternative D states that the land use designations should reflect the current zoning, and this will relieve the county of possible lawsuits, thereby relieving the taxpayers of this burden. Additional points about Alternative D Alternative D promotes the protection of property rights to the maximum extent possible under state and federal regulation. Existing residential neighborhoods shall not be rezoned by the county to accommodate higher densities except by a 2/3 affirmative vote of affected property owners. Development of infrastructure would be the responsibility of property owners, as it should be. The owner would collaborate with infrastructure providers as they do now. Problems with the groundwater depletion would be solved primarily by the property owners. And development should be market-driven, not planned. The current market should determine what the current market wants and needs. Our children and grandchildren will be perfectly capable of deciding for themselves. They should not be locked into anything that is decided now. The county must not change the rules after people have already put their money down, unless the county first obtains permission from the property owner. If there is a dire need, justly compensate the property owner. Our supervisors took an oath to uphold the Constitution, and that includes protecting property rights. So please call your supervisor and tell them to protect property rights and to support alternative D. We're researching our next steps. If you see the property rights-based alternative on the ballot, please vote for alternative D. Thank you.
Now we have so much more knowledge than we had before. We can bring Ruth back up here. Then we also have Mike, who's been very quiet and very well behaved. He'll not sign it. And then we can answer questions. We'll open this up a little bit further. Okay, do we have questions for Tanya, Mike, or Ruth? There's a hand up there.
Now you said they voted for a mixture of B and C, and we're trying to propose alternative D.
Pardon?
We're trying to propose alternative D.
Yes, we present.
Where are we in the, how can we get that back before the supervisors?
At this point, we're still researching what we can do. The general plan process is, a many-year process going on right now. And to continue on their path, they had to come up with a land use designation blueprint so that they can make more decisions about housing element, a water element, some other pieces on there. So in that April 20th meeting, that they decided that this is their vision of how we're going to use land. Okay. Even though we presented them with this, they rejected it. All 5 supervisors voted against alternative D. They all had it in plenty of time. They all chose this one so that they can now start building the rest of the general plan around it. In terms of what the government has said is going to happen, there's one last community input meeting before they finally approve it. But they spent $750,000. These maps I got from them. And they're going to do an environmental impact report. After spending probably nearly $2 million, I don't see it likely that they're going to just throw that all away and do an alternative D. But right now, all we can do is to call our supervisors today and say, hey, we want to go back to property rights, start thinking about it. If there's some thing on what we can do with a proposition, things on the ballot, those are still being researched.
Yeah, the next question, is it possible to get a referendum from the people where they can speak up and just overrule that whole system and say, we want respect for property rights? Yeah, it's a referendum from the people. Now, I don't know. Now we're going to ask if that's possible.
The referendum question. Well, honestly, I can't speak to referendum. But if you'd like us to speak on the referendum, I'll definitely be back to you on that, if that's possible.
Oh, yeah.
Would you please?
I would. Yeah. Yes.
I'm a little confused with what I heard from Tanya. Say I live in Calaveras County and I live on 5 acres and I like a rural lifestyle, but my neighbor has 40 acres. He decides he wants to build 120 homes on those 40 acres. Should he have the right to do that, or should I have the right to say, no, you can't do that? I'm not sure where we go with this. Who
Right.
we protect the
No, I understand.
likes all that open space, so the guy that owns the property wants to build a bunch of
Right.
houses.
No, I understand your question, but it depends on what were the rights that he had when he purchased that property. And when he purchased your property, he had those rights. And so it's just a matter of, you know, buyer beware, know what you're moving into, know what the properties around you. Make sure you're moving into an area that, that is suitable for your desires and your needs. And if you don't, you know, want to move into an area where the guy next door can build apartment buildings, then you better check that before you move there. And if that person, now if that person did not have the right to build all those apartment buildings when you moved there, you moved into a country area and you made sure that the neighbors were a country area. For him to change his zoning, he has to go through a process which includes checking with the neighbors. So it would not be right for him to change the zoning if all the neighbors, you know, we're counting on him to have that as country property. Does that make sense?
We talk about the property rights of everybody, and everybody's property rights affects everybody else's. So it's a process of you know, looking out for everybody's property rights, rather than always, you know, saying, oh, there's the one guy who wants to do a thing. There's a process in place. If you want to change it, you actually say you got to amend the general plan. That's what it shouldn't be easy to change zoning. It shouldn't be easy to do whatever you want to do. It should go through a whole process. And that's what Alternative advocates.
So then are you, and I'm just doing devil's advocate here because I understand what you're saying, but so then the inverse of that would be that if the neighbors don't want you to change the use of your property, then your neighbors now have a greater right over your personal property rights?
Well, you buy your property with certain, under certain terms and conditions.
But in the state of California, you have the right to make an application to change that.
And that goes to the process of neighbor input is part of the process.
Right, but the neighbor input is only part of it, you know, as in that decision-making factor. It should not, see, what I'm trying to say is it right that your neighbors can cancel out your private property rights? That's the basic.
Actually, can I speak to that? Because actually, I think you're right. I mean, I think that you guys are, right now what you're proposing is probably, under the circumstances, probably the best thing you can hope for as far as protecting private property rights goes. But I think that he's right, because you know, individuals, you know, your property rights shouldn't be contingent upon what other people think their property rights. Now, obviously, you have to be considerate of what neighbors and things think. But I mean, as far as what your rights go, I mean, you know, in Florida, for example, we're looking at a statewide initiative, kind of like what we do with propositions here in California, which will allow the community to vote on each and every project that comes up. And that's not really a great thing. I mean, because that really takes away the property rights of the individual and makes it contingent upon what other people think that they ought to have. And we actually went to the Supreme Court second to last time we were there on this case called Palafolo, challenging, well, people think, and understandably so, you might think, well, if I acquire a piece of property and there's a regulation already in place, I can't challenge that at the taking. Yeah, you can. Because we went to the Supreme Court and won this case. You had a property owner in Rhode Island who bought a piece of property, and when he acquired it, there was regulations in place, but the regulations were so oppressive that it wouldn't allow him to do anything with the property. So we went all the way up there and we won that case. So just because regulations are already in place does not necessarily make the right, does not necessarily null and void your property rights.
Thank you. Right now, Bill.
Yeah, just to clarify one thing here, that I don't think it's been lightly put over the fact that Tanya and Mike has said that you have to keep an eye on what's going on in the general plan right now, because what this gentleman said here could happen to his property. It may, or Mr. Cole's over there at the far corner, it may change the land use of that particular piece of property to something what he did not think was his right to do at the time. And that'll be done in somewhat of an open hearing, but it is so convoluted, this process that we have right now, that it's very hard to figure out what's going on and what's happening. And there is, a couple of us people have gone and talked to what they've done at Tuolumne. You can go look at the general plan, how they did it at Amador, where it was a hell of a lot less convoluted than this one is being done. I resent the fact, as a constitutionalist and a person who was born in this country, that the fact that there are only 3 choices in the box put together by Minter Harsh to let us know, this is our 3 choices, you have no others.
But we changed that.
But that's what this couple have done, and a number of other people have done, has put up this other floater that the supervisors have totally ignored. And I was at the general plan, what would they call it, no, it was the joint meeting between the planning commission and the supervisors. Personally, I don't think they work very well, but that's just me because I'm kind of the way I am.
Oh, you were the tall guy there.
Yeah, exactly. But one of the things that was amazing to me that there was, and I'm not sure the numbers, and this was what concerns me more than anything else, there were the numbers of at least 25 people who concerned themselves with their individual property rights at that open hearing. And no supervisors addressed it. They were concerned about how the county was affecting their constitutional rights, and no supervisors addressed that problem. Luke was exactly right when he said it in one sentence, and that's my opinion only, is that the way you make change is you make change with the people who vote the change.
All right. So, real quick questions, I we're going to say.
This one is, addresses this issue. I think it was a county in Minnesota where it was getting down to what was going to be passed, nobody wanted, but they're going to do it anyway. So the citizens calculated what losses would be all together, and then they presented it to the Board of Supervisors, and it was an either or. This is a lawsuit you're going to face, which will bankrupt the county, or maybe we can work together. And
I read about that.
And we researched that. So that, now, can we do that?
The short answer is, you know, like, if one threatens a lawsuit, there's always a chance that someone may settle. But the takings analysis that I explained a moment ago is it's not cumulative. It's property specific. So, and unfortunately, you know, if you could have a 100-acre piece of property, and the regulation could take away your ability to use 80% of that. It's not necessarily taken. That's the state of our jurisprudence today. So you can have 80% of your property devalued. It's hard to say. I mean, to what the test is, as I put it, you have a taking if you're denied all economically beneficial use. So if they take away 90% of your property, do you have an economically beneficial use? Well, can you still build a house? You know, like this is what you're, and if the answer is yes, it's usually you're going to be stuck in that Penn Central test I explained about, which is very muddled, and it's sort of a crapshoot whether or not you'll win. So some of it all is threaten litigation, and you know, maybe you'll scare them a little bit. But as far as actually winning a suit, you usually face an uphill battle with the property owner.
Well, it never went. It's simple. They agreed to work together.
Exactly.
They use it as a club.
Well, you can always use things as a club.
Hey, Steve?
I have a quick question. Cutting to the chase, what choice do the supervisors have? What if they all said no, we don't want a general plan? What is what can the state do, or and what if they just say no, we're not going to do that? What choice do they have?
Well,
I mean, are they in the box? They can't do anything other than what they're told to do?
It would kill
I mean,
development.
they're legally obligated to create a general plan.
Why? What if they don't? Does somebody else come in and enforce one?
Well, whenever a state actor takes an
We
action,
vote for these people. They vote for us. If we tell them say no, and they say no, who punishes them?
Well, they end up punishing anybody that needs anything other than a ministerial permit. Or if you need to have a zone change or anything that is a discretionary permit, anybody walking by can file a suit. They can do it from Los Angeles and shut you down, challenge the county and everything else. The people that pay for not being current on your general plans are the people that are trying to do something.
probably extortion. Well, it's not just the state that would enforce it, it's probably also,
Any sort of interested group, probably.
NGO, Sierra Club, they're all, they'll sue they're the first one to sue the county.
That's why you should not be looking at the general plan as an adversarial type of document. What you should be doing is looking at it as a tool that you can use for development. And what it's being done right now, it's being used as a regulatory issue, like in Tuolumne County in the late 80s and early 90s, where they overregulated, they killed development. All of a sudden, government didn't have any more money, and they started shrinking, and they go, oh, what did we do wrong? And what they did to fix their problem is they threw all the rules out, and they started over again, and they became pro-development, and lo and behold, they started having money. So it's all about money. And if you were to take a look at this general plan, instead of looking at a big adversarial thing and start, creating economic zones, get government to work for you. Get government to make the permitting easier in the areas that you want to develop, and then you leave the other areas alone. And the general plan gets amended periodically. It has to by state law. And then as you outgrow those areas, you re-amend your general plan. Everyone thinks this is going to be like the Constitution, which it's not. It's not cast in concrete. It's a fluid document. And it's designed that way because they know when you're making plans for big areas, you can't see everything. You're going to stub your foot and you're going to go, oops, well, that wasn't a very good decision there. And you got to change it. And it's a living document. And that's the way you got to view it. And we have not, as in this county, and we've spent over $1 million with a consulting firm that has failed to educate this county of what the general plan really can do for the county. And that's been the biggest problem. And we're headed down. Mike's been around for a long time, and he knows. Tuolumne hit their head against a block wall, and they're sorry they ever did it.
We have another question? Though it's a good speech.
My concern is that, to answer your question, we currently have a general plan. And the problems that we have today are because we have not implemented the things in the current general plan. And my position has been from day one when this conversation started about the general plan, is let's look at the current one. And let's go from there, because there's a lot of good aspects to that current general plan that merely needs to be updated. And I think that's the starting point. And I think that we have all agreed with that, and let's use that as the basis to move forward. And that way we have our property rights, we haven't changed anything, and then look at it from the perspective of bringing in new business.
Good point, Believer. Now, we're going to segue to talk about the Constitution. We're actually teaching the Constitution, believe it or not, in our county. And we have a lady that's in charge of that, and Shauna Hogan, and she's just going to talk for 3 minutes on that because we chewed up the rest of the time already. Shauna, tell us about the Constitution class.
I'm going to surprise you all. We have a big, fat, bloated government.
Surprise.
We have a government that's out of control. We have a government that's incompetent. Look at our economy. We have 10% unemployment. Look at the way they handled the disaster in the Gulf of Mexico. I think their first reaction after sitting on their hands for 8 days was, let's send some attorneys down there and create a commission.
Blame Bush.
Yeah, man blame Bush. Yeah.
Outlaw attorneys.
Look at the irresponsibility of the health care bill and cap and trade. We have a government that's grabbing power and taking our liberty whenever they get the opportunity to do it. Knowledge is our power. Knowledge. We have to gain knowledge. We have to teach ourselves, teach each other. Knowledge is our power against this big government power grab. I'm conducting a discussion group that Al mentioned. The group, I mainly put the group together so that we could all learn and teach each other about our nation's founding, about our Constitution, and about our rights, our God-given rights. The intention is to educate ourselves so that we can have the confidence and the knowledge and the basis to teach our neighbors, to teach our friends, to teach our acquaintances. And the reason for this, the big goal is to elect representatives that are ethical, to elect representatives that actually uphold the Constitution and actually also uphold the rule of law. This is what our country needs now, and I know I was at the Tea Party on 9/12, and afterwards I walked away from there thinking, what can I do? What now? What next? You know, what can we do? And what we can do as citizens is teach each other and teach ourselves and learn, so that when we go to the ballot box, we're informed, our neighbors are informed, and our friends are informed, our families are informed. This is what our country needs. This is actually our peaceful revolution. This is what we can do to take over and stop this downhill on wheels slide towards socialism. The class that I'm putting on is called, well, it's actually a discussion group. It's called We the People. We meet every third Saturday in Valley Springs. The next one is on June 19th, and that one we're going to discuss the details of Alternative D. Mike and Tanya will be there presenting. We'll focus on how it relates to the other three alternatives, especially regarding property rights. There's flyers at the back table, and I'm around for questions if you have any questions. I can take some questions now if you have a question.
Do you have a phone number?
It's on the flyer.
It's on the flyer, okay.
Derek?
2 quick points. You said something that was really, really important and crucial. God's given rights. But if it's possible to take God out of that picture, then who is given the rights? Government.
The government gives the rights, right? And when the government gives our rights, they can take them away.
Right.
And that's what I started.
The other quick point is, this isn't so much a nation of laws as it is a nation of lawyers.
It's the 99% of them that give 1% of that name.
That's a good answer.
Al, I want to know why you keep advancing the New World Order and the progressive movement. But you do. You have been.
Social justice.
And actually, many of us do. I used to get really unhappy with President Bush, the last one, because he did.
Yeah. Incidentally,
I'm an American. This is not America. This is the United States of America. New World Order, the new progressives, we're all a big happy family.
Yeah, right.
We're American.
Dominate state rights.
Citizens of the United States of America. Not America.
Get a hold of that little booklet back there. It only costs you $2. We're promoting a free America. Okay, yes.
There you go.
I just want to make a comment on his thing. I just took a survey yesterday on the phone, and the polls for what are you? Hispanic, Latino, Native American, Black. I says, I'm a Native American, and everybody that's born in the United States of America is a Native American. I told the pollster. I says, I don't belong to a tribe. She says, what tribe? I says, I was born here in the United States of America. That makes me a Native American.
All right. They tell them the CCTA. I belong to CCTA. Moving right along now. We're short in time for our assessors. You know, the Taxpayer Association, we try in our public meetings to bring in people that, we sponsored 2 candidates nights, and we didn't have the assessors part of the thing. The assessors part, a lot of taxpayers, you know, are learning about assessors, what they do. And so having both the assessor candidates with us is part of what we do. And so we invited both of them to be part of it. Now, on the program, I show Christy Dorian as the candidate that's running in opposition to Leslie Davis. However, her last name on her card is Reisman. So it's Christy Dorian Reisman. And so if you hear Dorian Reisman, you know you're talking about the same lady. Chris, why don't you come up here and talk about your program a little bit, and then answer some questions, and then we'll have All right, Leslie, come up here.
Thank you very much. I appreciate the Calaveras County taxpayers for inviting me here today. My name is Christy Boring-Reisman, and I would like to be your next Calaveras County assessor. The California Constitution requires that only 4 elected offices be elected by a vote of the people: the supervisors, the sheriff, the district attorney, and the assessor. Because these are the offices that have the potential to limit your life delivery and your pursuit of happiness. Elections are not simply about giving human resources a hand with hiring the most experienced, qualified candidate. Elected officials are supposed to be one of the people. They're here to represent you, to assure that your government is truly acting by the people and for the people. The primary duties of the assessor's office are to locate, map, and value all the taxable property in Calaveras County. My professional and educational background has made me a value expert on Calaveras County properties and uniquely qualified for this position. I'm a licensed real estate broker and have been involved in over 4,000 real estate transactions over the last 17 years. I've spent the last 17 years assisting my clients in realizing their dreams of home ownership. This position requires a deep understanding of fair market value, appraisal standards and techniques, construction methods and costs, and the unique qualities of Calaveras County properties. I review hundreds of appraisals, negotiated purchase contracts, tax bills, deeds, legal descriptions, and parcel maps every year. And the process of obtaining mortgage loans on properties often includes resolving issues dealing with easements, title complications, and appraisal problems. I'm also familiar with the laws, rules, and statutes governing local taxation and can pull it all together for you to assure that Calaveras residents are assessed fairly and timely in all market environments. My assessor's office will hold accountability to taxpayers at the highest priority. Fairness and transparency will be at the top of the list. Transparency is more than just giving access to information. Transparency is about making the taxpayer part of the process by creating better synergy between the assessor and the citizen. If representation is important to you, please vote for me on June 8th. Thank you.
How do you feel about property that's kind of unused or undeveloped, that's of some size, being deemed open space in the future of the B&C plan? Does that that's a shitty thing to do?
Absolutely. Although as the assessor, I'm not going to have direct control over the usage of property. But it definitely has an effect on value. If you take something that has, as an analogy, if I sell you a car for $10,000 and then I take the engine out of it, then what you just bought isn't worth what you thought it was exactly. So that certainly has an effect on value. I'm a huge advocate of personal property rights. And so from my perspective, downzoning from what was there when you bought it, what you thought you were getting, is completely inappropriate. Certainly you don't have the right to upzone, that because when you bought, you were told, if you buy something that's some rural residential 10, for example, they can't go back and tell you, no, you have to go to A1, but because that would be a down zone. But also, you can't, if you buy something that's R10, you can't say, well, gee, now I want to divide it up into, quarter of an acre pieces. That's not necessarily a guaranteed right, but I'm definitely not an advocate of forced downzoning.
Would you promote D to the people you talk to?
I'm not familiar enough. Yeah, I haven't read it. So If I was being asked to vote on it, then I would certainly read it.
I got you.
Yes.
I understand we have a lot of appeals to taxes, assessor, and we formed a new body for that. Do you have any research you've done on that?
Of course, an appeals court was formed to be able to hear the large volume of assessments or assessment appeals. Prior to, I believe it was last summer, the Board of Supervisors doubled as the Board of Equalization for the purpose of hearing assessment appeals. But the volume of those was too great for the supervisors to be able to handle it. Yes?
Just quickly, the assessor puts out a market value on your house and then another value for your taxes. This market value that they create, is that useful in determining the value of your real estate for selling purposes or?
Not necessarily. The assessor's office actually doesn't create the market value. The fair market creates the market value. So for example, if you go out shopping for a home today, you may find a home that's listed for $200,000 and everyone who's shopping in that area can see the house. The seller obviously wants to get the highest price that they can for it. So whatever the seller and the buyer negotiate is typically considered to be the market value. So let's say that you pay $190,000 for that house this year. Proposition 13 is going to limit the amount that your home can increase for tax purposes, that your assessed value can increase. So the maximum that can increase is 2% per year, or the CPI, whichever is less. So over the next 5 years, if it increases by the 2%, then you're going to be limited on what your assessed value is 5 years down the road. But your actual appraisal value could be higher if, depending on the rate that values go up. So if the market continues to increase, then your appraised value could very well be $250 in 5 years, but your assessed value is going to be limited to where you started today with the 2% increases. Does that make sense?
Yes.
Any questions? All right. Yes, it's our acting assessor, and she's running for election. I made a mistake, and it brought my attention that I call her an assessor because she is one, but she's actually an acting assessor because she hasn't been elected, and she's not being re-elected. She's being elected now if she wins. Thank you.
Yeah, I wrote Al an email this morning and said, please fix your program, and he said, too late, it's already been printed. My first reaction today was to say, hey, I thought you had great questions for Luke, great dialogue going on, and maybe I shouldn't talk. Nancy's got her program ready to go, but I'm afraid that since Christy talked, you might see it a bit insulting if I don't say a few words, so let's see how fast I can get through this. At your luau last August, I went over what the assessor's office did, and I talked to you about my qualifications, and I really don't feel compelled to do that again. Let me talk to you a little bit about what I've been doing since I became assistant assessor and then acting assessor. In 2008, I initiated an outreach program to the public to explain what we were doing to process declines of value. And this past year, I started an outreach program to school boards and fire district boards to talk to them about what that impact in declining values was going to do to their budgets. Last year, I streamlined the roll correction process to improve the time it took us to refund money to taxpayers. It also reduced internal costs for staff and the use of other supplies like paper. This year, I eliminated the requirement that business owners all file their business property statement. I reduced that requirement to brand new businesses and those owners who are required by law to file. I am the only assessor in the state who is using that as a criteria. The other 57 assessors happen to think I've lost my mind. And the State Board of Equalization, who's currently auditing us, is criticizing that practice because they think that by not requiring the business property statements, we might miss some assessable property. What else am I working on? I'm currently proposing a project to eliminate unnecessary parcel numbers and conform our maps to the new digital era. Our maps are currently based on 1968 drawings that had to do with 11 by 17 pieces of paper with 1 inch nice white boundaries around it, so they don't conform to the electronic age. So we're working on trying to change those maps to conform to the modern era. I've been busy identifying homeowners who may qualify for a tax break but who haven't taken advantage of it. On Friday and on Monday, I mailed out about 2,800 letters to property owners who may qualify for homeowners exemption but don't have one. I am astonished by the return rate. Yesterday, we received about 5% of those back with applications for property tax exemptions. And we're processing them in time for local. I can do those things because I have experience in government, I understand the law, and I can make these changes quickly. When property owners started calling about declining market values, I was able to create a process for us to use our existing technology to reduce those values and do it quickly. At the same time, I've eliminated 40% of our management positions so that I could save jobs. Every year since I became assistant assessor, I've brought that department in under budget. I'm not talking about hundreds of dollars, I'm talking about thousands of dollars. We're on track to do that again this year. Much has been said about the increase in appeals in our county. I could go into those statistics with you, but I think it's better to put it into context with the rest of the state. Across the state, appeal filings have increased substantially. In Madera County, filings increased from 53 to 791. At the high end of the scale, you might think LA County, they increased from 15,981 to 53,824. And in Merced County, they went from 186 to over 4,100. As a result of those increases, those counties are looking at an appeal processing fee. That's a charge for taxpayers to appeal their property value. I happen to believe those fees should not be allowed and are illegal. I think there are about 12 counties that have those fees. When those fees are imposed, taxpayers are discouraged from exercising their right to disagree with the assessor's office. And in fact, in Stanislaus County, their reported appeal count went from 1,540 to 691, which is proof positive that those fees are counterproductive. You may know that the legislature continues to play with the concept of a split roll. Split roll is the proposal that commercial and industrial property be assessed every 3 years instead of getting the same protections that you and I have under Prop 13. I oppose that for a number of reasons. Administratively, it's a nightmare, but more importantly, I do not think California business should be shouldering the higher cost of government. I hope you agree too, and when you see it on the ballot, it's currently a proposed ballot amendment. I hope you're not fooled by the fact that they're proposing an increase in the homeowner's exemption just to make it a little bit more palatable to the voters. Along the lines of the audit that we're getting by the State Board of Equalization, there are other criticism besides the business property statement filing requirement that I'm not requiring, is that we're allowing property owners too much time to respond to our request for a preliminary change of ownership statement. The law says they have 45 days. And if they do not comply within 45 days, there is a mandatory penalty. Now, that mandatory penalty is $100 or 10% of their new tax value, new taxes, up to a maximum of $2,500, and wait for it, whichever is greater. When that 45 days passes, the assessor under the law is required to impose that penalty. It's been my policy to give property owners another 15 to 20 days, and in practice it's going about 30 days. And we're going to get a criticism in our latest audit and survey because I'm allowing more time for property owners. I think it's important for assessors to err on the side of taxpayers, and that's what I think I've been doing for you. It's been my sincere honor to serve each and every one of you for the last 10 years. Al, I know that you want to take questions, but gosh darn, it's after 2. I know some people want to go home.
Well, we had a
especially over the last couple hours. And right in the middle of that, we had some good food too. We want to say thank you. One of our leaders, Bob Mulvaney, who's vice president of our organization, went to the hospital early this morning, and it was no, he didn't have a heart attack, but it was something else apparently. And his wife called me, and I haven't found out what the latest is happening with him. But he's been a real soldier with our group, and he's poured in hours and hours of work for the taxpayer. And so we wish Bob Mulvaney speedy recovery. He's in Sonora Regional Hospital. And with that, anybody have anything to go to the order?